everybody. I'm Elizabeth Beatty, the head of the in-house lawyer services at Harrison Clark Rickaby's. Thank you for joining us today for this session where we're going to focus on avoiding the potholes in the road to court proceedings and the rules that parties need to comply with to avoid costs and other consequences. We're going to have a look at today the pre-action reach of the duties owed to the court, the key ingredients of pre-action conduct, the different pre-action conduct schemes that apply and making the right choice, sanctions for failure to comply, and the relationship between court pre-action conduct schemes and contractual dispute resolution procedures, and limitation of actions, amongst others. There's quite a lot of us to get through today. Before we start, a little bit of housekeeping for you. This is a Zoom webinar. It's being recorded, will be available to review again by you and your colleagues in the future on our website. It's intended to be interactive, so there will be a short presentation from us and then over to you for your questions and comments. The key for us today is the message is that this is part of our series of added value sessions for our in-house lawyers. It's meant to be relaxed and allow you to pick the brains of our experts. If you aren't comfortable asking questions on camera, you can ask a question via the typed chat facility at the bottom of the screen. What we're going to have is a short presentation from my colleague and fellow dispute resolution partner, Dominic Hopkins. And then following the presentation, we'll then open up the panel to field your questions. For the panel, Dominic will be joined by our head of dispute resolution, Beynon. So Dominic, over to you.
Thank you, Beth, and good afternoon, everyone. We live in a curious world. Donkey's years back, I remember a client came into my office and he said to me, Dominic, he said, I've got a claim against this defendant. I'd like you to issue proceedings, please. I said, oh, that's fine. Let's look at it. He said, do it this afternoon. I want them served tomorrow. And I duly did that. And that piece of litigation carried on. Well, that was then. What we're talking about is the now. So the starting point is to look at what we're going to be discussing today. The state of the road, so to speak. Potholes is a familiar picture for all of us at the moment as we travel around the roads of the UK. And some of them are large potholes and you can fall into them. Some of them are smaller ones and they're still going to cause you some damage. Otherwise, others you can negotiate. So we'll be looking at some ways of negotiating those potholes, small and large, in the course of this presentation and question and answer session. Just the ingredients of the presentation. First of all, we'll have a quick look at the pre-action reach of the duties owed to the court. It's an existential moment for us all. I'll come back to what I mean by that. You've got the key ingredients of pre-action conduct, what really the parties are expected to do. There are a range of pre-action conduct schemes that apply, and therefore choice is really important. So we'll be looking at that. And the so what question, which is what are the sanctions for non-compliance? There's also a relationship between court pre-action conduct schemes and contractual dispute resolution procedures. That's quite a knotty one, which we can perhaps return to in the discussion period as well. And we'll also touch on arbitration. Limitation of actions, I cannot stress how significant and important that particular issue is. And then we'll be talking about how we apply pre-action conduct strategically. Next slide, please. Actually, we'll go on to the next slide, a journey back in time. And this is the existential question, because since 1999, should we call it 2000, the world began to look different. We had Lord Woolf, who introduced a new idea of how we should be conducting litigation through proposed reforms of the civil justice rules. The civil procedure rules were introduced. And curiously, that coincided out there in the outside world with a number of developments where courts were essentially, jurisdictions were extending their reach. So the US Patriot Act came in 2001. And that was one of the first bits of legislation, which basically meant that parties were, governments were actually looking to extend the reach of their law into other jurisdictions. We saw that impacted through the Bribery Act 2010 in the same way in this country. And so what we have there is a scenario where you've got courts beginning to look outside their own jurisdiction and saying, well, actually, we can affect things that are going outside our world. We're talking about that extra jurisdictional effect. Viewing the world through the lens of antecedent conduct. Those who are involved in insolvency will know that insolvency office holders spend a lot of time looking at the reach of insolvency legislation in the period prior to the commencement of insolvency. And it is a similar idea here. We've got the judges who are basically saying we're going to look behind the issue of proceedings. We're going to see what the parties have been doing beforehand, and we're going to tell them this is how we think they should be acting. Action and reaction, a world of consequences. That is not without sanction. So essentially, your conduct pre-litigation has an impact in litigation. What does this mean? It means we need to think ahead and not simply be responsible, as I did to that client, by simply issuing a claim form that afternoon. They used to be called writs in those days. So key questions, and these are fundamental questions for any litigation lawyer, anyone who's a party looking forward to the potential for litigation. And the question is, has a dispute emerged? Or might a dispute emerge? Because it's about being prepared. Next slide, please. So when we've identified there is a dispute, or there might be a dispute, what do we need to think about? What are the courts going to expect of us? Well, first of all, they're going to want to expect us to take stock. I'll come back to why that's quite a reinforced expectation a bit later. But what does that mean? That means that we're expected to exchange sufficient information to understand each other's position. You have two protagonists on the stage. Each is expected to exchange information, so the other knows what the other's position is. And the expectation is that is sufficient information to make decisions about how to proceed next. It's about looking to the future. That the parties have tried to settle or narrow the issues between them. Now, this is actually an issue which is becoming increasingly important. When the pre-action conduct rules came into play, it was all about have the parties tried to settle the case. Now it's extended to have the parties tried to narrow the issues between them in order to achieve the purposes of the courts, the overriding objective of the court, of the civil procedure rules. The parties are expected to have actively considered some form of process to assist in those efforts to settle or narrow the issues. And their conduct is expected to be conducive to the efficient management of the proceedings. Think costs, think court time. It's also that the parties not just have thought about how the proceedings might be efficiently managed, but have they tried to reduce the cost of those proceedings? Reasonableness and proportionality of conduct is central to the court's expectations of the parties in the pre-action period. Next slide, please. So what are the key ingredients of pre-action conduct? Well, first of all, the parties are expected to, at least the person who's got a claim is expected to notify an intention to claim. Now that's critically important in the arena of, for example, professional negligence. Those cases where insurance plays a significant part. In fact, as we will go on to discuss in relation to specific protocols, in the professional negligence pre-action protocol, there is a specific requirement for an early notification of intention to claim on the expectation that the other side may well have terms of their insurance policy that expect them to notify a relevant circumstance. And that is for both parties' benefit. One, that a party won't lose the indemnity available under their insurance cover, but for the other, that they will have a party which is worth suing, somebody who's got basically a policy that's sitting behind them to give them an indemnity if the defendant does not have the resources to discharge the liability of the claim. The second expectation or ingredient of the pre-action conduct, which is part of this, which is the requirement to preserve evidence. There is a duty to the court on both parties and solicitors that they take steps to preserve evidence. There is a very detailed duty in the context of the business and property courts for the disclosure in relation to the preservation of documents, specifically with a view to electronic documents. And we can talk more specifically about how that duty is made up. The third ingredient is about that exchange of information. Now, when the protocols for pre-action conduct came in, the practice direction was first instituted back all those years ago, the emphasis was on actually quite detailed letters being produced, letters of claim being produced, setting out pretty well everything that represented your claim, as if it was a full particulars of claim. Now, the courts have stepped back from that expectation now, but you are expected to set out basically the basic nature of your claim and the facts which you rely upon to support that claim. Another ingredient is that the defendant will respond to the claim that is alleged and explain in that response the basis upon which they will be doing so. We served last week a letter of claim pre-action, and that was met with a pretty well three-line response saying the liability was denied. That would not be reasonable pre-action conduct because there wasn't sufficient information to set out the basis upon which that claim is being met. Cooperation, and this is a really fundamental part of what the courts expect parties to do, to cooperate, to collaborate with a view to achieving those expectations which I've just been speaking about. That may well involve party-to-party meetings, solicitor-to-solicitor meetings. It might involve, particularly in disciplines such as the area of construction, expert meetings, technical expert meetings, specifically there with a view to narrowing the issues, working out exactly what's at stake, what's central to the resolution of the claim. The need to consider whether the case is suitable for pre-action alternative dispute resolution, or as in the commercial courts now, they describe it as negotiated dispute resolution. What's in a name? A little bit of irony there. They are essentially the same, which is there a way to solve this problem outside of the jurisdiction of the court, outside the place of the court? And that might be mediation. It may be one of a number of other options, which could include an early neutral evaluation, an expert certification, whatever it might be. Have the parties considered, with a view to satisfying those expectations, whether the case is suitable for pre-action alternative dispute resolutions? The answer might very well be no, because you may not have sufficient evidence to be able to reach a view on whether or not that would be a successful procedure. The courts don't expect parties to enter a procedure which is bound to fail because the parties simply don't know enough about each other's claims or the key evidence is not available. Pre-action offers to settle. Again, that can often be forgotten, but the rules of court provide a series of mechanisms, including under Part 36 of the rules for offers to settle, which have sanctions, which can have those sanctions if made prior to court proceedings. Again, one of the tools of pre-action conduct. Next slide, please. The importance of choice. Again, an important point, because you can make the wrong choice quite easily. Claim valuation is quite important because there are certain types of claim, certain types of protocol that are referable to claim valuation, particularly, for example, in relation to debt claims. The relevance of the claim type: are you seeking financial or other relief? For example, if it's a housing disrepair claim, there's a particular protocol for that. So what the type of claim is might determine the relevant pre-action conduct procedure that applies. And that brings me to the point of the practice direction. All this began with the introduction of effectively a default set of principles, the pre-action conduct and protocols practice direction. That was to apply in circumstances where there was no protocol, and that remains the case today. It is the default set of rules. It has seen a variety of revisions, but it is essentially sets out the default position. There are, in fact, 17 separate protocols as we speak, and there are more often have been debated. These ones that I've identified are ones which might, for example, be referable to business disputes, particularly construction engineering, media and communications. Those two, the defamation protocol and the construction and engineering protocol, all began, they were the first protocols of all back in 2000. When the Wolf reforms were brought in. Then you have a specific debt claims protocol, which is referable to claims debts of a certain value. Judicial review, that's a very important, it's a very specific type of procedure. And there are a variety of real estate protocols that may apply. In the personal, when you've got a dispute which involves individuals, there are a variety of others, which include personal injury, disease and illness, possession claims, and even package travel claims. So there are very specific protocols. So making the right choice is important. And once you've identified that there is a protocol that might apply, you've also got to think forward to where the proceeding might end up, where the dispute might end up, if it might end up in one or other of the high court divisions. Whether it could end up in the Chancery Division or in, for example, the Commercial Court or the Circuit Commercial Court, because each of those has their own guide, and those guides provide some additional narrative to inform how you should look at the protocol performance of the protocol. Some of them place greater emphasis on certain aspects of the ingredients of those protocols. So choice is quite important, and thinking forward to where the destination, where that road of potholes might be going. Next slide, please. What could possibly go wrong? Sanctions for non-compliance. The court has certain tools. I've identified a few here. If the parties have not been adopting appropriate pre-action conduct, then it's possible that the court will stay the proceedings so that the parties will go and act in the way that they should have before proceedings. They might, for example, say to the parties, no, you need to exchange documents, enter into an ADR process before we're prepared to go forward, depending on what the circumstances are. And the court might actually make a direction which doesn't allow certain amendments to the claim if you haven't actually gone through the process of trying to narrow the issues before the proceedings. The most commonly discussed sanction, however, is legal costs. And as I've set out here, there are a variety of possible sanctions here. The party at fault to pay all or part of the costs of the proceedings to date, the party at fault to pay costs on the indemnity basis, the imposition of fixed costs, and separately as a financial sanction, a claimant might be deprived of interest on damages, for instance, for a period. So those are sanctions that the court might have. There is another sanction which is probably worth making a reference to. There is an instance where and this is in the case of Jet2 Holidays Limited against Hughes, Master of the Rolls, reviewed the nature of the protocols. And the point that arose in that one was that the court could actually hold somebody in contempt of court in respect of a proceeding, a conduct that had taken place before the proceedings had been issued, and where in fact proceedings were never issued. What we had here was a witness statement. There was a witness statement which was subject to a statement of truth and had been in fact included fabricated evidence. And in that case, the court held that even though there had been no relevant proceeding issued in relation to that particular evidence, that contempt, the court could still find the signatory of the statement of truth guilty of a contempt of court. That's that extra jurisdictional reach that the courts have. Next slide, please. As Beth introduced when we began this session, we will also look at contractual dispute resolution procedures. Not unusually in commercial agreements, those involving complex, often long-term relationships, you might have a procedure which the parties have agreed to right at the outset as how to either avoid a dispute, or when a dispute arises, to find an efficient relationship-saving process for its resolution. Those procedures might include an escalation up to a senior management level before another step is taken. It might include rights to be given information, to obtain information, which might help solve a problem. It might require the referral of a technical issue to an independent expert under an expert appointment procedure. It might even require the parties to mandatorily submit themselves to a mediation or other alternative dispute resolution process. Contractual rights. Which has primacy, the court or the contractual rules? And the answer to that is that the contract rules do not give way to the court, and the court rules do not give way to the contract. Each of them has different significance. So, for example, if the parties do not comply with a contractual process, then that default is a breach of contract. It might be something that could be enforced specifically by the courts in the context of a court, an early stage of court proceedings. Proceedings might be stayed to enable the parties to actually fulfill a contractual obligation which they had agreed as between themselves as a pre-action process. But by the same token, the contract rules do not relieve the parties of adhering to the court's rules, the rules of procedure. So neither has primacy one over the other. They should be looked at for their individual significance and a route found to ensure that each is followed, or at least if you're not going to follow the contractual route, that you've understood what the significance, what the implications of that might be. Arbitration is by way of essentially a private litigation process which is agreed by contract, has its own significance. It may well appear as an ingredient of that contractual dispute resolution procedure, and if there is an arbitration clause, then the courts will customarily stay those proceedings to enable that arbitration process to be followed. The problems can arise where you've got competing contract procedures. And a very good instance of this is one which I've recently been handling for quite a complex advanced engineering claim. In that particular case, you had a contract for services and a contract for the supply of products. They were complex technical products. Each of those arrangements between the two parties were governed by separate contracts. Each of them had different contractual procedures for the resolution of a dispute. The dispute itself engaged both problems, the services side and the supply of goods as well. But each of them had arbitration clauses in them. One of them had an arbitration clause which gave the seat of the arbitration to England and the other to Geneva. How do you find your way to decide what is the procedure you should be adopting for the sensible resolution of that claim? And there, I'm afraid, it comes down to the common sense of the parties and their legal representatives to find an agreed route for pre-action conduct. Next slide, please. Limitation of actions. Time waits for no one. And the courts have been very clear, it's embedded in the court rules themselves, that essentially limitation trumps all. In other words, you are not expected to fulfill the requirements of pre-action conduct rules before you issue your claim form to protect yourself from the effluxion of time against a period of prescription in law. So it is important there to recognise that a party might well have to issue a court proceeding preemptively, even though the pre-action period has not been followed, pre-action protocols have not been followed. The use of standstill agreements is a way of ensuring and enabling the parties to effectively fulfill that requirement. There are standstill agreements, limitation standstill agreements remain an area of controversy in terms of their effectiveness, but they are still a tool which can help to ensure that no party is prejudiced by not issuing a claim form before they have gone through an appropriate pre-action period of conduct. I should say, in another case that I have at the moment, is that a major global company, following rigorously the contractual procedures for pre-action conduct, actually decided that they weren't going to issue a claim form in recognition of the limitation of actions problems they were facing, I think partially because they thought they didn't have to, and that they had to contractually follow the procedure before they issue their claim form. Well, I'm afraid they do so at significant risk in that case. Next page, please. Being strategic. This is an opportunity here just to look at a few points which perhaps my colleagues Wayne and Beth can add into as we just go through it. The importance of homework. I'm not working for home here. This is about actually doing your preparation, making sure as a solicitor representing a client, we'll want to undertake quite a lot of questioning of our clients, interrogating the circumstances around a claim to help us decide what is the right process for the resolution of the dispute, and working with our clients to chart a route, a strategic plan, a case plan. One of the points which I often discuss with clients where you've got cases, disputes which might well end up in the High Court is to, for example, produce right at the outset a costs budget, which essentially helps plan how much it's going to cost, what commitment you make to your pre-action conduct. That can help inform that key point which we began with, which is reasonable and proportionate conduct. We mustn't forget, of course, the court rules provide tools, for example, to obtain disclosure of documents which are necessary to be able to make a claim. You can apply before the proceedings have been issued for orders for pre-action disclosure. There is a cost model associated with those applications, which mean you have to think quite carefully about whether to make the application, but they can be part of that strategy for pre-action conduct. Offers to settle, we've talked about. Part 36 offers, centrally important to think about making an offer. I say think about making an offer. Commonly, you may decide now is not the time. The most strategic time to make an offer to settle is when you've actually got sufficient information to make it effective, either to present a picture of risk to the opponent, or to make it an offer that actually has a real chance of being accepted. We mustn't forget as well that you will have potentially have before the event insurance cover that you have already purchased that may be relevant to the dispute that is arising, the type of claim that's arising. And in those circumstances, discussions with the insurer centrally important in actually charting the most strategic, appropriate case plan in that pre-action period. Likewise, litigation funding and after the event insurance are two very important aspects of modern litigation practice, which means looking at whether or not a case might need to have some assistance in its funding, or certainly a policy being purchased to lay off the potential risk of adverse costs awards. And the reason that is an important component of pre-action conduct is because it takes a considerable amount of time and preparation in terms of establishing the necessary funding arrangements and the insurance policy. Like all good comedy, it's in the timing. And that really is very important. It's about working through when you do things, what you do and when you do it. And each case will be different. There is no set form for it. So please be patient with your litigation solicitor as they look to establish the nuances that might determine what is the appropriate strategy. I hope that's a helpful picture of some of the issues to be thought of as we face the prospect of litigation. Now I think there's an opportunity for some questions. My colleagues no doubt can chip in with their thoughts on what we've just been talking about.
Dominic, thank you very much for that. It's really useful. I do have a number of questions to work through before the hour is up. First question I've got, and I should also introduce as well. I mentioned earlier that for the panel, our head of dispute resolution, Wayne Beynon, is joining us. So Wayne, thank you again for joining us today to assist with the Q&A.
My pleasure. Afternoon, everybody.
So the first question that we've had from Zoe Moore Martin is, when involved in litigation with a litigant in person and they are not adhering to the pre-action rules, what recourse does an organisation actually have? Gentlemen, I'll let you fight it out as to who wants to get with that one.
I think the first principle, before Wayne chips in and gives me the right answer, the first principle is that the rules apply to everyone, including litigants in person. It does require, there is an expectation that by the court that the parties won't take advantage of litigant in person. And certainly, if you are a claimant, then it is important to ensure that the litigant in person has a copy of the necessary protocol or copy of the practice direction that is going to be applied. So you might refer to that when you're defending a legally represented party to the protocol, practice direction. But in the case of a litigant in person, they should be provided with a copy. And of course, it is in your interest to ensure that the litigant in person who's a defendant understands their position, and that may require you to go to explain the issues in simple and more straightforward terms, and the courts will expect the parties, solicitors, legal representatives to act in that way. Wayne, do you want to comment?
No, I agree with everything you said there, Dominic. It's that fine line, isn't it? Your role isn't to advise your opponent or your litigant in person, but you do need to appraise them of the court rules and the consequences for them if they fail to comply with them. And I think that's pretty much the only tool available to us in that pre-action stage, is to ensure that if proceedings do prove necessary, the litigant in person is going into those proceedings fully aware of the consequences of having failed to engage in a reasonable manner at a pre-action stage.
If you're happy for me to add something in here, because some of my experience is dealing with litigants in person when I'm in court, and the rules do apply to them, although it does feel before you get to the courtroom that they don't think they do. And often some litigants are sort of a bit, you know, they're very robust about it and just seem to think it's a little bit of a game, and until they reach the court, and sometimes they come out with a bloody nose, and then they realise actually this is quite serious stuff we're dealing with. But there's recent case law that's very clear that if a litigant in person does not adhere to the rules, they are likely to be subject to the same sanctions, their case being struck out, subject to costs orders being made. And I've dealt with those, and there is an element of latitude if people don't understand the procedure. And as Dominic and Wayne have said, you're obliged to provide them with copies. If you refer to a relevant rule, send them a copy of that rule, not try and blind them with science. But there's a point at which, especially when they're the claimant, it's their claim, it's for them to produce the relevant documents to support the claim, it's for them to adhere to the rules. The test for a relief from sanctions for failing to comply with court rules, and that, I mean, pre-action rules as well as during the course of litigation, they bite on litigants in person. The frustration you have when you're dealing with one who thinks it's just they're out on an exercise just to make a bit of money, is that often they don't realise the game's up until they get right to the end of the process, and the judge takes a very dim view and slaps them around the head, metaphorically. And at that point, then they pipe down. But it is very frustrating. The issue for solicitors dealing with them, whether they're in-house lawyers or those in private practice, is that in addition to what we're required to do under the court rules to deal with litigants in person, we've also got our code of conduct, which we must adhere to. And part of the code of conduct, the key principles, is that we must uphold the rule of law, and we must deal with people in a polite and professional way. And so whilst we'd love to tell litigants in person what we really think of their incoherent, sometimes incoherent correspondence and their behaviour, we have to temper that to make sure that we don't overstep the mark and are perceived as bullying them in some way with our expertise. So it's a careful balance, but they are subject to the same sanctions and requirements as we are if they don't adhere. Sorry, that was rather a long answer, but there you go. Right. We've talked about the sanctions for non-compliance just briefly there. Wayne, perhaps, can you answer, are they often, in your view, are they often enforced, or have you experienced of when they've actually been enforced, where people who failed to comply with pre-action requirements? Yeah, well, as Dominic's explained, the primary sanction is when you get to the conclusion of proceedings and the parties explain to the court why one or the other party should have to bear the costs of their opponent. And it's there that you have the opportunity to explain to the court why their pre-action conduct was didn't comply with the court rules, the pre-action protocol. And what you tend to find is that the courts will consider pre-action conduct in the round together with the conduct throughout the litigation to determine what, if any, sanctions to impose. But absolutely, I've been involved in a number of cases where a party or my opponents failed to properly engage on a pre-action basis and have been penalised on costs at the conclusion of the proceedings. So, that is the primary, one of the primary reasons we talk at length to clients about the need to comply with pre-action protocols. But ultimately, though, those steps that the court require the parties to take are underpinned by sound reasoning. We've talked about the obligation to explain to your opponent what the case is about and give them an opportunity to respond. And that, like I say, it's not just about avoiding the sanctions that the courts impose. It's about ensuring that both parties properly understand their claims, properly understand to the extent possible what evidence is available on each of the issues in dispute,
so that they can properly analyse and assess with the support of their legal advisors what approach to take, whether court proceedings are necessary or whether it might be more appropriate to fully explore settlement on a pre-action basis. So yeah.
I'll just add one point, which is that the courts find petty arguments between solicitors in relation to the pre-action conduct unprepossessing conduct in itself, and will commonly find it, the solicitors can find themselves on the wrong end of a raised eyebrow from a judge if they simply come in and say, I'm really sorry, that particular claimant didn't give me 28 days, he only gave me 21 days to be able to respond, or the small petty arguments can actually go in relation to pre-action conduct, can result in a court taking a rather dim view about the solicitors and the parties themselves. And it is important, I think, just to emphasize here that the rules in relation to pre-action conduct don't just bind the solicitors, the solicitors acting, actually bind the parties as well. It's the parties and the solicitors themselves who are embraced by this scheme of rules. And it's quite interesting there when you talk to colleagues in different jurisdictions who first of all think that pre-action conduct is a bizarre idea, but also to find that actually both solicitors and clients themselves are bound by this set of rules. They just find it completely bonkers. I have to say, I suspect they may find it'll come to them eventually through their own jurisdictions, but it is a significant aspect of the sanctions regime that the courts do look very carefully at whether or not the parties and their solicitors have conducted themselves reasonably and proportionately. It may be a case that the technical specific requirements of a particular protocol have not been met, but there might well be a very good reason for that, as long as the parties have given thought to it and shown what they that they have taken account of that scheme. And just on one point, which I think it is important, I use the phrase "taking stock," and the practice direction on pre-action conduct and protocols includes a relatively new requirement here, and I think this is really quite telling. And I'm going to read it in full. It says. This is item 12, paragraph 12. It says, where a dispute has not been resolved after the parties have followed a pre-action protocol or this practice direction, they should still review their respective positions. They should consider the papers and the evidence to see if proceedings can be avoided and at least seek to narrow the issues in dispute before the claimant issues proceedings. So it's not just take stock once, is take stock twice, even when the parties have followed the protocol and the practice direction. Have you done enough to satisfy the court's expectations?
Thank you, Dominic. I mean, I think that taking stock, I mean, it's mindful of the overriding objective of the civil procedure rules. It's that obligation continues, doesn't it? Before, immediately, pre-action, immediately before, and during. So it's just an ongoing obligation. Wayne, a question for you here, if I may. We've talked about compliance with pre-action protocols, but are there any instances where you'd say that there might advise clients not to comply with them, or the basis or the logic behind doing that?
Hey, that's a really good question. I have acted for clients in the past who have specifically instructed me not to comply with the protocol, much in the same way as Dominic was instructed to do so before the Wolf reforms, purely to reinforce what the client perceived as being a reputation for being aggressive, litigious, and a party that just would not settle matters easily. The client, I think, enjoyed having that reputation, and as a result wanted me to reinforce it by not spending a month or two in pre-action litigation correspondence. But what I always advise clients is it can be quite counterproductive to take that approach, because inevitably we're setting this, looking at claims in a pre-action stage, and there may be a chance of having to issue proceedings and pursue the claim all the way to a trial. Setting out your claim properly in writing and engaging properly in the protocols that are applicable demonstrates to your opponent, particularly if they're represented by competent legal advisors, that you know what you're doing, and you know what the rules say, but also that you've got one eye on recovering costs at the conclusion of the claim. So that in itself sends a message that your client is serious about the litigation and is prepared to invest and take it all the way to trial. So in that situation, after having explained to the client the pros and cons, because I understood the point that the client was making about reputation in the marketplace and just shooting from the hip, as it were. But the decision was taken to comply with the protocol because, on balance, that was the correct thing to do.
It's probably worthwhile making one additional point here, which is often in a commercial context, you really are looking to find the earliest possibility of a settlement. You want to, you don't want to commit to your lawyers for the next 2 years. If you possibly can. It might be ultimately what has to happen, but you want to do it. And one of the benefits of the pre-action period is that neither party is subject to an adverse cost risk at that point, albeit the pre-action costs will come into play when proceedings are issued. Essentially, if you are a claimant and you're looking at the ingredients for a settlement, then you can make your decision on what basis you enter into negotiations and how you proceed without worrying that in that period you have to deal with the potential of the management of a costs order to exit proceedings. That can actually be quite an influential factor in leveraging risk, both for a defendant and for a claimant. A good example of that is a case where I recently had a professional negligence claim in a commercial context. It was a developer. And what took place was right at the outset when I sat down with the client, it was pretty clear that the client's reluctance to issue court proceedings and to bear the risk of an adverse costs award. Now, what that meant strategically was I had to invest considerable amount of effort in the liability, establishing liability against the insurer, so the insurer is aware of the merits. So we really did front load that case so that we didn't get to the point of having to bear the adverse cost risk. And we, by doing that, we leveraged a mediation pre-action and a settlement, which meant the client didn't have to make that commitment and decision of issuing proceedings and exposing themselves to adverse cost risk.
Really, so what comes off the back of that, Dominic, is that in doing so, you're incurring major, extensive legal costs before you get the ability to recover them in court proceedings. Does that really feel reasonable and proportionate? And obviously, if you do settle, do you put it, you might take an overall global settlement figure, but some people push for their costs too, and other parties said, I'm not compelled to pay your costs, I'm not going to. So it becomes a sticking point somehow if you front load it, which is achieved in one hand a settlement, but then you've still at the cost point. What are your sort of views on that?
Well, the negotiation in that case depended upon being confident ultimately that there was a liability, that actually this was a good claim, and it was a good claim. If it was if the view was that it was perhaps more questionable, it was maybe 60-40. This case, although a complex loss of opportunity claim, ultimately it was pretty clear there had been negligence, and really what the case was all about was about quantum. It was about causation, and the result was that in that case. But you are absolutely right. For cases there isn't. If you invest a large amount of time and effort and costs pre-action in contexts where you're not going to be able to use the court mechanism for recovery, then big questions about reasonableness and proportionality come into play.
Sort of managing clients' expectations. If you want to achieve an early settlement, you may have to just forego your costs effectively just to do the deal.
I'm pleased to say that in that case, the insurer agreed to pay all costs pre-action, as well as a big chunk on the liability side. So
yeah,
that was a good outcome, but it was individual for that particular client.
The bigger driver, well, as big a driver is the need to de-risk the claim and ensure that you understand as much about the claim as possible.
Yeah.
When I was a junior lawyer, a partner explained to me that litigation was like dropping a pebble in a pond, and pre-action you only have one ring of information, and as you proceed on the route to trial, you build that picture about your case. But fundamentally, the more you and your client understand about the issues in dispute and what evidence is out there pre-action, and that may involve some investigation and some cost, the more you can de-risk it and the more precise you can be into trying to determine the outcome. So, yeah.
I mean, it's the same as you say. Sorry, go on, Dominic.
I'll just say to one flag for sort of drafting commercial contracts, of course, is to when you're thinking about the cost indemnity provisions that you're preparing in relation to your commercial relationships, think about the costs of the pre-action period and don't limit them in when you're drafting simply to those costs incurred in proceedings. Sometimes I've seen cost indemnity provisions related exclusively to costs incurred in the proceedings, bearing in mind that you might want to have a leverage of a cost indemnity that cover all costs, including cost of investigation and pre-action conduct costs.
Thank you. So, just picking up where Wayne left off, when you sort of talk about understanding the risks, de-risking it, it's important when there's an element of front loading on certain claims. It isn't necessary, but on certain other claims, you really do need to do a lot of front loading in order to put pressure on the other side to deal with liability, whatever it might be. And it does perhaps feel there's an awful lot of front loading of costs going on there. But of course, if you want to achieve a negotiation, ultimately nobody wants to go to trial. The only people who benefit then are the lawyers. But you have to be able to understand your strengths and weaknesses to negotiate. So inevitably, you've really got to pause through the evidence. So you can perhaps take witness statements, sometimes depending on the nature of the dispute, which does incur huge costs. So if you have got contract documents in place where you've already considered, as Dominic said, if we end up in a situation falling out about the services or goods supplied under this contract, we've got already worked out what the cost provisions will be or how that will be funded. That gives you more certainty, because one of the worst things about disputes and litigation, there's one certainty: it will cost a lot of money if it goes to trial, but the rest of it is very uncertain world. So to build in when you can't prevent disputes happening, but you need to build into your contractual relationships with your service providers and your customers and clients and so on, provisions to address what happens if we do fall out. And part of that is it's the de-risking right at the beginning before it pops up, as much as when you have to, it lands on your desk and you've got to assess it before it goes to court or arbitration. Right, I think we've got time for maybe at least one more question here. Let me see which one it is to choose from to factor it all in. I think one of the questions is, what practical steps can I take pre-action to minimise the risks associated with litigation? I don't know, Dominic, would you like that one to start on that one at least?
One of the practical steps to minimise the risk of litigation is what comes back to that de-risking is making sure you have captured your evidence early, and that means the duty that the parties have and solicitors have to preserve evidence is a very practical duty, because it helps you give structure to that need to capture the critical evidence, the electronic documents that you might have. I have a case at the moment which I had to spend pretty well 3 to 4 days working with this institution to work through the practical way in which they needed to ensure that the relevant evidence was quarantined that it wasn't lost by a document retention procedure that effectively deleted documents after 6 months, that actually we'd identified all the custodians of evidence, and we had ensured that there was safety around those documents, identifying the individuals in the institution who are going to be key, because we have a lot of witnesses that we need to look at and make sure that we know whether they're going to be kept on board or not disappearing out of the door, where we can actually capture their evidence. So a practical way in that early stage, practical step is the capturing of evidence, whether that's documentary evidence, electronic evidence, or whether it is witness evidence, making sure that you know who your witnesses are going to be and you can track them and know and ensure that you're able to find out what they will be saying in the event of a dispute. That's part of that, I'm afraid, expensive front-loading exercise, which can be very expensive but can be very worthwhile when it comes to actually adding the leverage you want to achieve against your opponent.
I'd agree with that 100% in terms of preparing yourself or your company as well as possible for the eventuality that you end up on the road to court proceedings. But in terms of practical steps, even before perhaps parties instruct lawyers, we always talk about dispute avoidance being, part of our toolbox as litigators, and talking to clients about, how to navigate away from the costly exercise that is litigation. And there's no fair dust. Communication is a big factor. Not always possible. Often when clients first instruct us, the relationship has reached a stage where it's almost irreparable. It's completely broken down, and they have actually tried to maintain good dialogue, but it just hasn't worked. But if you on a practical level, if you are having those early stage discussions around a potential dispute, it can help sometimes to have what we call a without prejudice conversation, so that the parties can discuss in an open and informal setting potential terms on which they might settle their differences without engaging their solicitors. I'd always advise clients to at least discuss potential disputes with their solicitors at an earlier stage as possible, so that the sorts of steps that Dominic was talking about can be considered in concert with potential ongoing discussions. But other than that, I think communication obviously is a big thing, and if you can obviously avoid having to issue proceedings, then that's the best outcome in any disputes, provided you can reach terms that are acceptable to both parties.
Thank you very much. Well, we've just 1 minute shy of 2 o'clock, so there are a couple of other questions received, and what we'll do is we'll come back to you separately, because I'm conscious we keep these sessions to the hour because you're also very busy. But I'd just like to firstly thank Dominic for his really helpful presentation today, and also Wayne for joining the panel today and dealing with the questions. If any of you have any questions coming out of this session and you'd like to contact us, our contact details will be provided. We'll be sending you a copy of Dominic's slides in the next day or so. Please do contact us. Those that already know us know that we're happy to have a discussion, a bit of brainstorming, or whatever it might be. The clock isn't ticking. It's not a no obligation discussion. So do contact us, because obviously we welcome the opportunity to understand the issues that are affecting you and your business. But for now, thank you very much for joining us, and we look forward to seeing you again for next month's session. Thanks for them. Bye-bye.
Thank you.
Many thanks, Beth.